Listen, this cross-examination, the one thing I've noticed with this witness and the prior witness, the apartment manager, is that both of them testified that they were told about a Native American man running with a stain on the shirt on 4th Street. In the opening statement, though, the defense said that the evidence would show the person was running away from the apartment. That may seem like a nuance, but to me that's pretty significant for the defense to now have testimony, oh, he was on 4th Street.
Yeah, material. And, you know, we've had this conversation before. As an attorney in the courtroom, you want to be a source of credibility, both factually and legally. And it's one thing to stand up in front of a jury and almost promise something in the opening statements, because that's essentially what you're telling the jury what they're going to be hearing. You're going to be hearing this. You're going to be hearing that a Native American was seen covered in blood running from the scene. That's powerful. You know, especially when I heard it, I was like, wow, you know, I hope all the leads were covered on that and they did the right thing with investigating that. But now, if that's different than what was purported by the defense attorney in opening, it really does make you think, is this a credible source? As attorneys, all attorneys out there, you want to be a credible source in the courtroom for the court and the jury at all times.
And you're my credible source for how to prepare for a case. So part of the defense is this screen with the backwards L cut just described and the broken or bent, I should say, not broken, bent part of the screen, and the argument by the defense that somebody could have come in through that. What do you think of that potential argument?
They're throwing everything at the wall. I mean, they're really trying. It's one of the things, too, when you're defending, if you're so specific about a particular third party, arguing third party guilt, you better be right. You know, again, this goes back to the credibility, but it's very different than stepping back and saying, you know, they have the burden of proof beyond a reasonable doubt, and you'll hear they haven't proven my client did it. But then when you start being very specific about the maintenance man, especially the maintenance man, now you got to actually prove it, right? And that's kind of what they're trying to do here. The screen, I mean, look, the screen was with the maintenance man in his area. And this witness, particularly for me, he seems very unsure. It's almost like this examination is being done in a living room at a coffee table. I mean, he doesn't seem very prepared. He's very, vague about some of his answers.
Well, I was going to say what's fascinating to me is every witness has said, I don't know, I don't remember. It was 18 years ago, so it's not surprising. But even the law enforcement personnel have not reviewed a report to prepare for testifying, it appears, because they still say, I don't really remember.